Yes, I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
Hey guys, and welcome back to the channel. Today we've got a beautiful disaster of a courtroom meltdown featuring a rare triple combo. A Karen, a full-blown sovereign citizen, and someone on a probation violation who decides the best possible legal strategy is to fire her attorney and represent herself. Yes, she really does it. So buckle up, because we're diving straight into State versus Ashley Clark, where chaos shows up before the judge even finishes calling the case.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here.
Oh, okay.
What your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it in the file.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other. When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
The moment the judge calls the case, State versus Ashley Clark, everything already feels tense. Her attorney politely steps forward to speak, but Ashley immediately starts interrupting, insisting that she does not consent to the name being used, as if saying those magic words will make the case evaporate. It's the classic sovereign citizen opening ritual, like reciting the national anthem before a sports game, except this anthem is made of nonsense. From the very first sentence, it's clear the judge is about to have a very long day.
Let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks.
Attorney registered by the city, state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm
Okay.
challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer that's in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right, well,
I'm
trial
challenging
date,
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not a
positions?
debate. It's my constitutional right. It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
denying
that-
the motion? Because you don't have.
Even
You don't
even
have.
if so Mr. Hicks, you're a grown man.
Just seconds in, Ashley escalates by informing the judge that she does not recognize this court's jurisdiction. Sovereign citizens love this line the way teenagers love saying, "You're not my real dad." The judge calmly tries to proceed, but Ashley keeps interrupting with pseudo-legal word salad about being a living woman and not the corporate entity listed on the paperwork. It's like she learned law from a comment section. The judge, to his credit, tries to stay composed, but Ashley is determined to test his patience one syllable at a time.
Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right. No, you don't have a right to either or.
Yes, I do.
Then comes the moment everyone expects but still can't believe. Ashley fires her attorney right in front of the judge. No plan, no preparation, just supreme confidence that Google and TikTok have trained her better than any licensed professional. Her attorney looks exhausted, like he's silently thanking the universe for releasing him from this assignment. The judge warns Ashley this is a bad idea, practically begging her to reconsider. But she refuses, convinced she's cracking the legal system wide open. Spoiler alert, she is not.
I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP15, SP1442547, counts 1, 2, and 3, SP1442761, and SP500872. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
Now officially pro se, Ashley tries to cross-examine the probation officer, but it becomes clear within seconds that she has absolutely no idea how questioning works. Instead of asking actual questions, she launches into rambling sovereign citizen speeches about contracts and maritime law, none of which have anything to do with probation, the case, or reality. The judge repeatedly tells her that this is not how hearings work, but she just keeps talking, drowning in her own fake legal theories. It's like watching someone try to fix a car with a spoon.
I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights.
By this point, Ashley is hitting every item on the sovereign citizen bingo card. She claims she's not the defendant, says she does not stand under the judge, mentions maritime or admiralty law, insists she's a living, breathing woman, and argues the court has no jurisdiction over her. It's the full script, word for word, as if she memoized it from a Sovereign Citizens for Dummies textbook. The judge looks exhausted but unsurprised. He has clearly dealt with dozens of wannabe legal philosophers who think saying "I do not consent" is a cheat code for
this. You were driving in the city of Lake Forest Park. You were violating
again. I was not driving. Again, I have rights.
You were behind.
My rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor. I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance. as well as concerned about community safety and risk of reoffending.
The state calmly presents evidence of her probation violations, missed check-ins, ignored instructions, and non-compliance across the board. It's open and shut stuff. Ashley, in response, objects using more sovereign citizen gibberish about corporate entities, contracts, and rejecting the claim. None of it is legally meaningful, and the judge knows it. He patiently listens, but there's a clear look on his face that says, I cannot believe I went to law school for this.
Defenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
After being interrupted for the 10th time, the judge finally raises his voice, telling Ashley to stop talking over him. But Ashley keeps going, talking louder and faster, ignoring every instruction. The judge gives her multiple warnings, each one firmer than the last, but she seems committed to the idea that if she simply refuses to acknowledge the court will cease to exist. Everyone watching can tell where this is heading, straight to jail.
And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
When are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented.
Eventually, the judge has had enough. He rules that she did, in fact, violate probation, something that was obvious from the start. Ashley tries to launch into yet another sovereign citizen monologue, but this time the judge cuts her off completely and moves directly to sentencing. The courtroom atmosphere shifts from chaotic to resigned. Ashley still doesn't understand that she has talked herself into a deeper hole.
Consequences for you, so it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself, sui juris in propria persona.
Well, if you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right, the time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said yes, you pleaded for me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I do not understand how you can practice law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty. So on your behalf, I'm entering a not guilty plea.
So correct, you are pleading for me, correct?
There's 2 pleas.
And if you plead for me, you're practicing law from the bench. You cannot practice law from the bench, so I object.
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay?
Jennifer Grant,
The judge sentences her to additional jail time, and Ashley desperately tries one last sovereign citizen spell. I do not accept this contract. The judge responds flatly, it isn't a contract, without a hint of amusement. And that perfectly sums up the entire hearing. Ashley attempting to cast legal magic spells and the judge calmly reminding her that none of them work. By the end, even the court staff looked tired. So what did we learn today? That firing your attorney in court is one of the fastest ways to self-destruct. That Facebook legal theories do not hold up in real courtrooms. That refusing consent does not cancel your case. And that sovereign citizen logic continues to be undefeated at getting people locked up. If you enjoyed this breakdown, hit that like button, subscribe for more courtroom chaos, and drop a comment telling me which sovereign citizen meltdown I should cover next. Thanks for watching, and I'll see you in the next one.